Okay, great. So I can see that we are live on YouTube. All right. Good evening, everyone. Thank you so much for joining in this session. Today, my name is Shweta Rath, and I'm accessing Komalcha's account, which has the name has been changed. Great. So today we are doing a series session on competition law, and we are joined by Mr. Abir Roy. Welcome, sir. Welcome to LawSikho for today's session.
Thanks, Shweta. Thank you.
Sir is the co-founder of Sarvada Legal, and Sir has extensive experience with competition law, litigations, and enforcement. Prior to this, Sir was working with Lakshmi Kumaran and Sridharan and was heading the competition vertical over there. And before that, Sir was with, as we call the erstwhile Amarchandan Mangaldas. So, Sir, once again, welcome to LawSikho, and thank you so much for taking this current session for today. Now,
Thanks.
today we have a very interesting topic that I know all of us wonder about, but we haven't really had any extensive debate or let's say a discussion on this particular topic. We've only probably read about it in bits and parts. So I thought, why not take up a session, kind of collating all these portions of the discussion into uh, one exhaustive session. So just before I start the session, I have one humble request to all of you. Please kindly do not unmute yourself because will have a number of participants in the session. If you have any queries, please feel free to put on the chat box. And after the session, we'll definitely take them up as a Q&A round. Okay, and this is so that the flow of the session doesn't get disturbed. So the topic that we are taking today is basically emerging trends that in competition law that are going to be key issues after COVID. As we all know that, COVID has brought the entire economy to a standstill. And right now, as the lockdown is being lifted, some companies have become functional, some have not. But needless to say, all of had faced a massive economic, uh, what we say, like a economic damage, so to say. Now, what we will be doing in today's session is we'll be discussing some essential issues that will gain some key focus after this whole COVID scenario is done with. Or let's say once litigations again start with full flow. And for all those who want to pursue competition law in future and want to, if not exactly become lawyers, but are currently working with companies, please ensure like you must know that competition and antitrust implications is something that all companies are going to face. Okay, so whatever we'll be discussing in today's session, I'm sure a lot of it will be faced by all of you in the coming months, at least in some ways or the other. So with that, let's go ahead with today's session. I understand that we already have a question from Mr. Lokesh Chandra, and I understand that some of you may not have much idea about competition law. So, sir, may I please request you to give a bit of a background into this very interesting and exciting piece of legislation, which everybody has some clue about, but not probably any concrete idea. Before we go into the main topic of our session.
Thanks, Shweta. Thank you, everyone. I hope all of you guys are doing well during these unprecedented times. Now, I'll just take, before I deep down into all the trends that we foresee in the next 18 to 24 months. Since there's a question as to what is competition law, I think the best way to answer would be that it's a market behavioral law which actually regulates the market conduct of enterprises. What we actually want is perfect competition, which is free and fair market where there are large numbers of buyers and sellers. If there are large numbers of buyers and sellers, the price would be low, you'll get good quality, and the consumers will be happy. Now, anything which disrupts this free and fair competition, whether by enterprises acting together or a strong enterprise, which under the competition law is called as a dominant enterprise, acts in a manner which disrupts this free and fair market behavior. So this is, and just as a backdrop, we all know why competition law is also known as antitrust law, which is in US. So I think to understand extremely basic without going into details of section 3, 4, because that will take another session or a
Yeah.
day in itself. I think just to have everybody on board, The name antitrust is basically in 1890s. So I'm talking about the 20th century now. What used to happen was that all these investments into companies were put in a trust. So it was the first case was Standard Oil Trust, which that trust had shareholdings across multiple oil companies. Similarly, there were other companies, other trusts which had multiple shareholding across various other companies. So ultimately, what used to happen was these trusts used to determine the market behavior of everybody. So that's why the US law felt that we need to do something to break these trusts. So that's why the name antitrust. So it's like an antidote. So that is as basic as I can be. And that is what is relevant in all the issues that we will highlight today. I, with that, I think that is the most basic I can be without going into section 3 says this, section 4 says this. But this is basically an our market law which determines or regulates rather the market behavior of enterprises which impede free and fair market behavior. That is the idea of perfect competition. So with that, I'll just go spend
Absolutely.
so I've what we have done is done some crystal ball gazing as to what will happen in the next 24 months. We are all faced with a situation which in our lifetime is unprecedented. I don't think we have ever faced this before. I think nobody could have predicted this. No business risk management company, nobody who is an astute businessman or in a board of directors could have predicted this behavior. So this is an unprecedented situation. So coming out of this situation, we are still in the middle, right in the middle of the first surge. So we do not know when it will end. But still, let us understand as to what are the kind of issues which we will deal with in the next 18 to 24 months. And I'll keep it as basic as possible because not going into the big terms, etc., because that will go into another issue altogether. So personally speaking, I have identified these 5 trends. So in enforcement, obviously, there's another area called merger control, which I have not touched. These are the 5 areas that we have identified as what is the future holds like for the next 24 months.
Yes.
First is COVID related issues and litigation. Now, what is that? You would see that all these prices of face masks and the PPEs and all the essential services have gone up. That's an unforeseen situation which is there, maybe caused with a demand shortage, maybe caused by other anti-competitive factors. Now, there are various antitrust authorities which are there. I've taken a note. There's EU which has come out with a notification. There's Italy, there's Poland, there's Norway, there's South Korea, there's US, there's UK. All saying one and the same thing. Obviously, the language is totally different. All saying one and the same thing that we are in an unprecedented situation. Please do not use tactics which are opportunistic in nature, which essentially means that you should not use tactics which harm the consumers in any manner in terms of higher pricing or lower quality. But as they say, the profit motive or greed takes over everyone. They are people, they are enterprises which actually engage in conduct like increasing prices, etc. In other jurisdictions, and there are jurisdictions like Poland, for example, they have stepped into this. What had happened was there were certain behaviors by wholesalers of these face masks, which they said will not supply to hospitals, but will supply at open market, just increasing their profit margin. So Poland came down heavily on that. Then Italy came down heavily on Amazon and eBay because they were doing excessive pricing of sanitizers.
Yes.
Unfortunately, CCI just came out with an advisory which essentially says that you can collaborate provided that is in public interest or innovation, as the case may be. But that to me is just rehashing the existing law as it stands today. What you need in certain times like this is for a regulator to stand up and take notice and maybe issue some kind of a stern notification or a guideline saying that no opportunistic behavior will be allowed. Why I'm saying so is the face mask. I was doing some Google search. the price of face masks have increased by 300% from the pre-lockdown era. Although face masks and sanitizers were brought in under the Essential Commodities Act, thus capping the price, unfortunately, the extent of the notification or the timing of the notification was only till June 30th. And I read somewhere that the ministry is not planning to increase that. So as on June 30th, the Essential Commodities Act, for example, which somehow caps the prices of these face masks and the raw materials for preparing these face masks or sanitizers, as the case may be, this restriction no longer applies. So now you will get a zoom in, not Zoom, the Chinese app, but the Zoom, the increase of the prices of these prices. And it's very, very essential for a regulator to come and step in to ensure these conducts do not happen. Yes, there are challenges as far as the law as it stands today. Can you go after such multiple enterprises? Can you not? But these are subsequent issues, in my opinion. At times, the regulator needs to come out and say these are the issues which are there, and do not engage in such conduct. Now that the CCI hasn't come out with those notifications, I'm of the opinion that there will be such kind of behaviors which will happen in the future, which will in turn lead to multiple litigations, because there will be filings before the CCI saying that AB's company ABC, which is engaged into essential services, be it anything, be it PP, hand masks, sanitizers, the works, all the essential services, are engaged in behavior which is increasing the prices. So please investigate. And CCI, considering the situation, may also initiate an investigation. And unlike other investigation, which takes in its own sweet time, for a lack of a better word, this will be a very speedy kind of an investigation. So this is one thing which in European Union is colloquially now referred as crisis cartels, which basically in crisis you come and form a cartel or whatever be that name it's called. Under Indian law and European law, there's no difference as such. So unless you can show that you have given some efficiencies to the consumers, efficiencies in form of that we want to pull in resources so that the consumers get all the prices, all the goods at affordable prices and quickly. We had to pull in our resources, like supermarket chains, example. So these are the things which will be very litigious in the next 18 to 24 months, is what I am of the firm opinion. So this is something, and we as Competition Commission of India should take reliance and should see the conduct which is happening on the west as well as on the east. We have all the countries all across the globe issuing stern warnings, issuing starting investigation. So, for example, Turkey has started investigations against 29 wholesalers already, 29 supermarket chains for increasing the prices. Now, the question can be, can you initiate an action against 29 companies if it is not a cartel behavior? But that is a subsequent issue. That is a litigation issue. That is an investigation issue. At least initiate an investigation. If you initiate an investigation, there is a high likelihood that this behavior may or should be curbed. So this is a trend which I'm definitely seeing in the next 24 months, is my first point.
So I think we can then safely say that a lot of JVs are in store. Like companies may enter into, they will have, do companies get incentive to enter into co-marketing agreements, or let's say sharing resources, or let's say co-supply agreements in this particular scenario?
Yes.
Do we see possibilities of that happening?
So yes, as a trend, as a compliance perspective, I am surely seeing sharing of resources, pooling in of research, R&D, co-marketing, like you said. But those are the, then as a compliance perspective, as an in-house perspective, or somebody who's advising the company, you have to make very sure that in the agreement and also in practice, it is leading to efficiency. Just creating a joint venture or just creating an agreement will not take you outside cartel provisions. You have to show that your JV has increased efficiencies in the market. Basically, not going to specifics. How do you increase efficiency? One will be administrative efficiency, that basically because of this huge demand and supply constraint because the factories are closed, the workers have gone back,
Yes.
you're only operating at 50% capacity, so your supply would be limited. So let's pool in all our resources. That way we'll have cost savings and
Yes.
consumers efficiency, because then you're giving all the products in time. But on the flip side of it, you should not be engaging in supranormal profit behavior. That okay, fine, we pool in our resources. There is a inherent vast demand. The supply is less, so increase the price, which otherwise would have been say 10 rupees. You are now charging 300 rupees, which unfortunately is happening now. Whether it's for cartel behavior or actual supply shortage is an investigation point.
Yes.
But this, I definitely foresee that there will be investigations in this regard in the near future. Once it comes out, you never know. Information could have been filed, because we do not know. Nothing has come out in the press to my knowledge. But you never know. Some information may have been filed. If not, it should be filed in the near future.
But sir, can companies take a defense? Like you mentioned that the in the agreement, it should be clearly stated that what are the efficiencies that are arising out of this particular agreement, which is not really the same that was there before. That agreements were not mandated to give out these things, but now agreements have to clearly state it. Can one such reason be, let's say, two companies feeling that if they don't enter into this agreement, they may go out of business, and to safeguard their future operations, maybe economic efficiencies are not arising, but just to safeguard their operations and to ensure that they don't go bankrupt, they enter into a collaboration. Will that act as a defense for
Yeah,
the
so
company?
this is colloquially referred to as a failing firm defense,
Yes.
wherein you are saying that if it continues like this, I'll go out of business. So I'm pulling in my resources, because if I go out of business, ultimately the consumer is harmed, because I will go out of business. So I am no longer a viable alternative in the market, because
Yeah.
I'm outside the market. So ultimately the consumers will be affected. But the reason is it's a very thin line.
Yeah, exactly.
It's a thin line where you have to err on the side of caution. When I say err on the side of caution as a regulator, at least investigate whether they are actually doing these efficiencies or not. As a compliance point of view, from a company's point of view, obviously these are the defenses that they will take, provided it's documented both in agreement and actual practice, whether it's agreement or internal white papers or board papers, whatever name you call it. It need not be a form of the agreement, but it should be a contemporaneous document. You should create it now, not wait for the litigation, because that will have no evidentiary value. And obviously, in practice, you need to adopt that. So it should be as so the standard is it should be proportionate to your efficiencies. So you should actually attain those efficiencies and enter into JV, which helps you attain those efficiencies. But having said that, circling back to my initial point, as a trend, I do see a lot of investigation which will happen in this regard.
Yes, sir. So now that you've said that you foresee a lot of investigations in future, but what is the current state of the Competition Commission of India in terms of being a regulator? Like, what is the state of the litigations? Is CCI entertaining any information, or is the CCI having hearings right now?
Unfortunately, in my cases, hearings have been deferred.
Right.
Uh, Information, yes, they are being filed, so that is allowed. But hearings haven't happened to the limited matters that I am doing. I'm told that there are a couple of hearings which have happened, but that is few and far between. On merger control, yes, apparently the green channel route and other routes and other things are going on. But
Yeah.
since we are sticking on enforcement, I don't think many hearings are happening. Especially in my matters, everything is getting postponed. Fresh matters filings is happening, but again, prime officer hearing is not happening. So that's a sad reality right now. I think the CCI should take cue from the Supreme Court and the various high courts and start online hearing, which one point I think sooner than later they will start, because they were worried about confidentiality, which I agree, because it's a business regulator. But they have to find some safeguards from one point of time to another, because the show must go on, as we say. So
Yeah.
the online hearings is the way for the future, for the foreseeable future. So it must go on. You can't have a regulator, especially a market regulator, and any regulator, be a securities regulator also. Even SAT has started. Securities Appellate Tribunal has started. So
Absolutely.
you can't have a market regulator which is functioning at a less than an optimum capacity. So that should not happen.
So you would, despite the current function of the CCI, you would still advise clients to go towards filing an information before the CCI if they come across any such disruptions
Oh,
that are happening.
oh, completely. The act. So, okay, I should have rephrased. The act is not suspended. The act is continues to exist. There's no suspension of the act. So, just as a layman, just to take a very offbeat, a very digressing example, there's no moratorium on the act. The
Yeah.
act is completely operational. There's no question of a company engaging in malpractices as far as competition law is concerned. So if individual or a consumer body or anyone for that matter, for example, as a dealer, if there's a very strong phase mass supplier which is not giving me the product, obviously a dealer can go and file a complaint. So I would certainly advise companies or individuals to file information. Let's not wait for that.
Absolutely.
There is a procedure which is given. There is an email address which is given onto the website. You obviously have to pay the filing fees, and
Yes,
they accept information by way of emails.
absolutely. So, great, sir. We can move on to the second point, that is private enforcement. If you
So
could give
this, yeah.
background on
So just to before I start with this, I think each and every point which I have mentioned in itself should take an hour, but I will try to encapsulate it as to the best extent that I can is possible. Now, generally under the Act, what happens is if you are found in violation of a cartel behavior or any entering into any anti-competitive agreement, or you've engaged in an abuse of dominance, you are levied a penalty. The penalty obviously will be contested. Obviously, it will go to the Supreme Court. The worst, finally, whatever the penalty is imposed by the court of the land goes to the Consolidated Fund of India. It doesn't go to the person who is informing. Thereafter, the informant can file a case for damages, which is private enforcement,
yeah,
before National Company Law Appellate Tribunal, not before the CCI, but the Appellate Forum. Now, there are certain cases which are going on as far as private enforcement are concerned. Excel Corp being one of them, and Shakes being another one more of them. So there are a few cases which are going on. Fundamentally, I believe that the private enforcement, if it takes off, will give much more teeth to competition law as a subject, as a market regulator. Why I say so is because if you have incurred a damage, you can actually file a case before National Company Law Appellate Tribunal. And based on the law as it exists in EU, etc., you not only get damages for actual losses, but loss in profits also, which is opportunistic loss. So, for what I mean to say is, because of your conduct, I have suffered, say, rupees 100 over the last 3 years. So, I'll not only claim that rupees 100, I'll also claim that if I had got rupees 100, I would have, say, set up more factories. I would have supplied more products. So that's an opportunity loss. Obviously, how to calculate, how to come up with a calculation is all an economic kind of a behavior. Economic evidences will be adduced. But you can claim that also. The law is silent. It says damages. But as far as the EU law is concerned, or the EU practice is concerned, you can claim both actual losses and loss in profits. Now, the difficulty which arises is you can come up with the figures in an abuse of dominance case, for example. I would say slightly on the easier side.
yeah,
But in a cartel case, for example, in a cartel case, you have found that there may be 5 participants who, under aegis of a trade association, had engaged in a cartel behavior, and materials were given to you at a markup price.
right.
Now, how do I determine how much loss I have incurred because of an action of a single enterprise or a trade association?
Yeah,
So that is one of the points. How do you apportion the loss? How do I apportion that out of 100 rupees loss, I apportion rupees 3 to company A, 4 to company B, and 3 to company C? How much? Then the question is, how much should I apportion to the trade association? Because at the end of the day, the trade association is just an association of enterprises.
yes,
How much do I apportion to the trade association that you had meetings under the trade association. The other issue is, which is now being debated in the Excel Corp maintainability case. It will go. I'm sure it will go in appeal. I was having a discussion with one of our peers. While a competition law action is an action in rem,
Yes.
a compensation action, in my opinion, is an action in personam, because I'm personally asking that you have, because of your conduct, I have incurred so many damages. So I need to show individual applications showing each loss from everybody individually on an individual basis. Can I then file a combined application against all of them, or should I file individual applications? So flip side, I can file class actions.
Yes.
But in a class action, the respondent remains the same.
Yeah.
That all these 10 people have suffered losses because of an action of you. So class action, it is, say, company A to company Z versus company AA, for example. But can I file? So that's a question of law. That can I file as a company a compensation application against company B, C, D as a common respondent? Because my claim against each of them would be completely different. So these are the kind of issues which will come up, but these are secondary issues in my opinion. As a fundamental point, I believe that private enforcement, I hope and I sincerely pray that it actually picks up, because that will give a lot of teeth to the competition authority, because not only you will have to pay penalty,
Yeah.
you would also have to pay damages to individual companies. So just to take an example forward, say in a cartel case, I have filed for leniency.
Yes.
Despite engaging in cartel behavior, I may have been the ringleader. Basically, for the easy understanding of everybody, ringleader is a person who is actually orchestrating the entire cartel. So I'm the main hero of that cartel, or the main villain, as you see it. I'm orchestrating the entire cartel, and then I go and say leniency, please give me 100% immunity, fine others. So while that leniency applicant may get 100% immunity, but as a consumer of that cartel, I can take him under a private action before National Company Law Appellate Tribunal. So if it picks up as a strategy before you file a leniency application, you need to keep that in mind, that a private action can be initiated against you. And a private action always is much more than the penalty, because you're, again, like I said, it's actual losses plus loss in profits. In MCX case, MCX has filed a compensation of 800 crores, whereas the penalty is only 50 crores. So I do not know whether 800 crores will be awarded. So obviously it will be heavily contested. But say for the sake of argument, it is actually awarded and upheld by the Supreme Court. Consider the kind of teeth that a competition law gets.
Yeah.
So this I'm genuinely seeing, because there are certain live cases going on before the National Company Law Appellate Tribunal. There will be a lot of jurisprudence which will be laid down on this point.
Absolutely. And we said that private enforcement is not something that has been happening in the past.
Yes.
But sir, what is the reason for that? Like, why is it that despite there being a provision for it in the Act, why haven't parties gone for private enforcement as much as we would like to see?
Because the law is designed in such a manner, because you cannot file a compensation application before the CCI. You have to file a compensation application before a National Company Law Appellate Tribunal.
Right.
Now, the consequence of that is you have to wait for a CCI order, which takes its own sweet time. Once the CCI order is passed, obviously you can only file compensation if you have found the opposite party guilty of Section 3 or 4. Those opposite parties definitely will appeal.
Yeah.
So National Company Law Appellate Tribunal will say, let me decide on the merits of the appeal, and then decide whether compensation should be granted. So, for example, CCI finds a party A guilty on 5 counts. The compensation application I will file will be on basis of harm which I have been caused because of those 5 grounds.
Absolutely.
NCLAT says no, not 5 grounds, only 3 grounds.
Yeah.
And then again, the party will appeal.
Yeah.
So there will be appeals and cross appeals. So unless the main merit of the matter has been settled by the Supreme Court, while you can file, it will not be heard, or the Supreme Court or the NCLAT has to come out with a via media to ensure both can run parallelly. So that is a novel approach that a regulator or a quasi-judicial body in this matter, that is a appellate tribunal and the Supreme Court, has to devise, which I'm sure they will devise in course of time. But that is a long and short answer, that's why it's taking so much time. But now, since it has started now, I feel that this will be a huge trend going forward.
Absolutely. Thank you,
Any
sir.
any questions on this?
Yes, guys. Any questions up till this point? I understand Mohit had asked a question with respect to the process to report what is the procedure to report in CCI in case of any unfair trade practice. But I think we can, in short, take up this question towards the later part of our discussion.
Okay, I already touched that you can file, so we'll touch on it later. I'll come
Yeah,
back to you, Mohit, on this.
yeah.
Now
Guys,
the
yeah, if there are any queries with respect to the first two issues that we've spoken about, please feel free to put on the chat box while we move on to the third issue. That is the issue that has grabbed so many eyeballs
Yes,
in the last 3 years.
yeah, and so this is the single largest issue which I see going forward, not only in India but worldwide.
Yeah,
Uh, just to give you certain stats so that you know, so that we know what we are dealing with. Uh, in 2009, among the companies, and I'm talking about globally now, not
yeah,
India, globally, in terms of market capitalization, only one tech company was there out of top 10. This is 2009, which was
yeah,
Microsoft.
yes,
We are in 2018. Out of the top 10 companies, 7 are technology based companies. You
yeah.
have Google, you have Facebook, you have
Apple, Amazon,
Apple, Amazon. Am I
Facebook.
missing some? Yes. So
The top
every,
five that we call the
yeah.
magic circle.
So which is called the big tech, etc.
Yeah,
Now, I've read through some literature, etc. One thing which I find, and there's a lot of reports. So
yeah,
recently, the UK authority came out with a report their authority came out with a report on 1st July on
yes,
this online advertising, etc. That there are various reports all across, and everybody is grappling with the problem. So much so, the UK CMA, the Competition and Market Authority, which is parameter of the Competition Commission of India, has essentially said that, sorry, the present rules are not sufficient to deal with this. Obviously, being a lawyer myself, I would say our law is sufficient enough to deal with it. I do not agree with that finding of the report, and I'll come to it when we are discussing this point. But the point is, the why one of the reasons why I always fail to appreciate is that how did they become so big without being checked? It is because the traditional, if say suppose I open a business and anybody opens a business, or the traditional norms of doing a business is I sell a product or a service and I get something in return. That's a contractual principle. You sell, you get money in return. These people, that is the Googles of the world, while they are highly innovative, they are highly much ahead of the curve, etc. If you search on Google, you don't have to pay. If
yeah,
you open up an account on Facebook, you don't have to pay.
absolutely.
So to that extent, whenever demand is zero, there will be more people coming in. So even the traditional norms of investment have gone for a toss. If nobody sees how much is your profitability which before I pump in money, they'll see what is your network. The idea has gone from creating a vast network to so from profitability to creating a vast network. But if it is for free, consumers are happy, so nobody complains. The authorities have also been slightly lax, for a lack of a better word, in checking their behavior. So they have become so big, and as there's a common saying, uh, power corrupts and absolute power corrupts absolutely. So now people are wondering, now that Google and Facebook have become so big, how do I regulate them? Because like the principle of competition law is being big is not bad, but I
Yeah,
need to regulate their conduct. How do I regulate their conduct so that they keep on innovating? They do not take their counterparties for a ride. Just as a statistic, Google and Facebook do a lot of advertising. This is called digital advertising.
Yeah.
And this, so I read through a lot of literature. I'm just taking some instances which we can relate to. There's just so much literature on this point. Even the regulators are grappling to on this. So coming back to digital advertising, the market in India right now is 200 billion rupees, or or is it 2000 billion rupees?
2000, I'm
Sorry,
sure.
yeah.
2000.
And in the 2015 it was only 40 billion. So this is the amount that they have gone so high. So they have grown so exponentially.
Aggressive growth, as we call it.
Yes, aggressive growth.
Yeah.
Now, even digital advertising, as per the UK report and all the literatures, are different. One is search advertising, one is display advertising. Search advertising is essentially that you want to buy, say, best speakers under 1,000. You press on Google,
Yeah.
certain advertisements will come. So that is search. I'm searching for a definite thing, and search advertising comes. Display advertising is what you see when you, just for a layman's example, when you drive by the road, you have those banners.
Yeah.
You may or may not require those banners, but the brand is there. So you may not want to buy a house, but you will have, say, a JP board that come to sector 62, you can buy a property. You're increasing the brand awareness. What the CMA report has found, this is obviously UK, India, obviously somebody has to do a market survey. Google is extremely dominant in search advertising. Facebook is dominant in display advertising. So much so, now how do I advertise? Somebody has to advertise. Demand is, from a consumer standpoint, consumer is not paying anything because it's zero. The suppliers of these advertisements who want to advertise their products on a Google or a Facebook are paying. So there is an agreement between a supplier and Google and Facebook respectively, which is known as an intermediation agreement. You have those Google AdWords, for example. There's the problem. And CCI is looking at this issue as to whether that is an abuse of dominance in itself. How are those agreements being structured? EU has already found them in guilty. Now we have to see whether in India, what is the investigation going forward. Statistically, again, but in the sense why I'm throwing statistics now is so relevant, because at the end of the day, like I said, it's a market driven law. While I would say that Google, everything is free because I'm searching
Yeah.
at free, but the revenue per search for them has more than doubled since 2011. And
Yeah.
for Facebook, for creating an account, the revenue that they get in 2011 was £5. Obviously, this is an UK report. So India, we have to check. Right now, it's £50 per user in 2019. So imagine the growth. So number of users have grown up exponentially. The revenue per user have gone up by 10 times. How do they get the revenue? From the advertisers,
Yeah.
people who advertise. So you and me, today, if we want to advertise our products on Google, that's where we'll get the entire issue.
Yeah.
Then obviously, if you buy an Apple phone, so then it struck me as to, then we were doing this. So this a colleague of mine told me, I'll just show you one more thing because the shares, sorry, just,
But also, I think these tech companies have their biggest supporters in the consumers themselves.
yes.
Like the
So
competition is being impacted, no doubt, but their biggest support comes from their huge user and consumer base. So if they start monetizing their services right now, the first the first section of, and like the first set of entities that will get affected would be the consumers, and that is something that I guess even we would not tolerate. Like, how do you actually balance those interests?
yeah, so see, these are the issues which are there. So there are
Yeah.
certain issues. So have you ever thought as to, when you buy an Android phone,
Yes.
why is Google always the default browser?
Absolutely, I completely agree with you on that.
So that means there is an agreement between Google and Apple.
Yeah. Like,
Imagine two huge tech companies having an agreement.
yeah, if it's an iOS, yeah.
So which is, and also I'm just having some technical problem. I wanted to show you something else also. Unluckily, I'm not able to show you because this. So I will stop share because there's some Wi-Fi issues at my place. But do this exercise. If you type on Google that I want to buy best speakers or anything below say 10,000 rupees, there's a tab which comes for shopping.
Yeah.
So you click on those tabs, a tab will come which will show, say, for example, speakers A, JBL, etc. Those are sold by Amazon or on Amazon site, for example. Let's not go sold into Amazon because then it's another issue altogether.
Yeah.
You click on that, you are redirected to the Amazon site, which essentially means that there has to be an agreement between Amazon and Google to list their products on Google Shopping. Because the principle is why I came to this is because I was thinking, why is Google so big in search advertising? Because if I want to say, I can understand if I want knowledge. So, for example, I want to actually read on competition law and big data, for example. I go on Google, Google will throw up its search results. But if I want to buy speakers, I'll go to Amazon's website. Why will I type on Google? So Amazon is also giving all those search options, etc. Then I was doing much, obviously, this is just my limited research. We need to research more. Amazon is catering to another kind of consumers where you actually want to buy and sell stuff. But Amazon itself is being listed on Google. So that basically means that Google, although they're catering to the same consumer, for example, but in a different capacity. One is as a search capacity, one is at a buying capacity or a selling capacity. And Amazon has listed their products on Google Shopping. That means there has to be an agreement between Amazon and Google. So to that extent, there must be an agreement, which again, so these are the things which needs to be investigated. There's already an investigation on Google default browsers, for example, on phone. This is the Apple case, which are there. Then obviously, another issue which comes up is how did they become so big is essentially because they had their slew of acquisitions, because they acquire periodically from time to time companies, which unfortunately fall within that below the radar of thresholds. So that's why they have become so big. There's no authority which has gone and checked them. I always believe law has to be adaptive in nature, cannot be reactive, especially a market-driven law. It cannot be reactive, while you cannot be proactive because you will always be behind the curve as far as tech is concerned. You can't be too reactive, and you have to apply your existing law to see whether there is sufficient scope to cater to this. So you would know, Shweta, that there's a lot of clamor among the committee that to reduce the threshold for tech or for pharma, for quote unquote killer acquisitions, for example. I
Yes.
ask myself the question, yes, it should be done, it should not be done. But under our Section 3, which is not there in Article 101 or Section 2 of the Enterprise Act of 1988 of UK, our law under Section 3, there is a word of acquisition, which is not there in other laws. So why can't, as a regulator, we be slightly nimble and proactive and say we can also look at acquisition agreements under Section 3? Let that be challenged. That's a different thing. There will be challenges to that. But as a regulator, I need to assume jurisdiction on certain things. I cannot let it become so big because of a lacuna in the law, which by the mischief rule of interpretation, or we call the golden rule of interpretation, can be brought in. Obviously, if it cannot be brought in, you cannot do it. That is an excess of jurisdiction. But if it can be brought in, why not? So these are the kind, and obviously then there's this another debate on e-commerce, which
Yeah.
is in itself a debate which I have spoken a lot and I'm personally invested because I'm representing one of the parties there. So I'll not go much deep into that. But having said that, this is another point as to while I will keep it short on platform neutrality.
Yeah.
Can a platform act as a both as a marketplace and as a preferential treatment to certain suppliers? So much so, if you read the newspapers right now, I do not know what will happen in the future when it actually comes. You have the UK CMA saying that our law is not enough. So please come out with new laws and regulations.
Absolutely.
Under the draft e-commerce policy, obviously it's newspaper reports. They have also said we need a new regulator, which will
Yeah.
decide fair competition issues. Which essentially, let us see the draft, obviously, because there will be data localization issues which are there, which I am not an expert to speak on. But these are the things which will come. Now, even if it comes, for example, let's go one step forward. Let's say, even if it comes, who will understand them? So you have market survey report, market search report, or whatever it's called, market study report, sorry, on e-commerce. They say that you have to make the terms and algorithms available, for example.
Yeah.
I can't understand algorithms. Most of the people can.
Yeah.
I'm not a technical person. In fact, so much so a noted economist, competition law economist, Richard Posner, recently said that even if they make it available, who will understand that? So,
Absolutely.
which essentially means the regulator, whether it be a competition regulator or an e-commerce regulator or any regulator, the court should understand that. And how will the court understand that is when you hire experts. So
Yeah.
these are the and this is the least I can say. So there are so many theories which are going on. I think Manish has also written something on this.
He has a
So,
very interesting question on this. Yeah. He's asking that there's an article titled as The Amazon Paradox by Lena M. Khan. What are your views on the concepts given in that which counters the theory of Chicago School?
so I am, to be honest, Manish, pardon my ignorance on this. If I don't know something, I'll not beat around the bush. But I know of certain articles. Maybe this is the article that you're referring to, which I remember one gentleman telling me, and I want to get hold of this article. He says Amazon has this theory of creating a new normal,
Yeah.
which essentially says that today, leave the law. The law is inadequate. So I will take so much data and I will make targeted advertisements. I'll create a paradox where you see the law on my practice as on today, but not as the law which was supposed to be there, which was supposed to contain such behavior. So they say that you read or analyze my practices from today, which is the new normal. Obviously, new normal right now is a lot of things are new normal. But having said that, this is so that's how Amazon got busted in EU based on this book which somebody has done. I don't know the books. I'll read and maybe somebody if they can help me with the title. It's actually called Amazon's New Normal, or maybe it's not the title of that book. Maybe they're dealing with it in the as a book, as they say. So they say that this is the new normal, which unfortunately is the case with all the big tech companies
Yeah.
or whatever big data companies, as you would call it. You won't imagine the biggest abuse that they have said in the CMA is use of personal data and fake news.
Yeah.
Use of personal data, yes, it's a data privacy issue, but why can't it be a competition law issue? The reason why I say it is because, say, suppose I'm big, I'm dominant player. If I use somebody's personal data to my advantage, why can't I bring an action against 4-1? Why has the CCI said that 4-2 is an exhaustive list? If it were an enumerative list, like the EU has said, then I can bring a data privacy issue by a big company under 4-1 also. So these are the kind of nimble kind of approach that you have to see, because the traditional norms of entry barriers does not apply here. It applies network. You create a network. Why do advertiser advertise on Google despite these terms? Is because you will get a lot of consumers. So it's a
The
positive
payoff
loop.
is great.
A
The
loop is
payoff
created.
is
It's
much
called,
better.
yes, it's called a positive loop, which is there. If a loop is created, good. You are innovative. There's no doubt Google is innovative. There's no doubt Facebook is innovative. But then, like I said, being big is not bad. But I need to. My law should be enough to regulate your conduct when you fall into the black line and not operate in the gray or the white.
Basically, it function in such a manner that you will make sure nobody has the strength to even compete with your, for that matter, even enter the market because you
Yes,
have become that big.
yes.
So,
So these.
I understand this being a very exciting topic. Like we're already flooded.
Let's take all the questions here. If I can answer, I'll definitely answer.
Definitely. But so may I request if we could just take the remaining two sections, after which we'll definitely do the Q&A. Otherwise, I feel, we might just not really cover everything. Or also, I leave it to you. If you want to take up the questions right now, we can. Sure.
So let me do one thing. How much time do we have? I'll
So,
quickly.
yeah, we do have 15 minutes with us.
Okay, so what I will do is I quickly finish
Yeah,
with the permission of everyone. I'll quickly finish the other 2 points, or rather, I'll only take one point because sectoral regulator and regulatory turf has been spoken about quite a bit.
quite a bit. Yeah,
Yeah, so I'll only take one, which is the hub and spoke. Sorry, I had to stop screen sharing because of my bad network connection.
sure. Not a problem, sir.
Uh, so the next trend which I had identified was hub and spoke issue. Now, what is hub and spoke issue is, just for a layman understanding, if party A and party B are engaged in a similar line of business and engaging in conduct which is basically fixing prices or limiting production, etc., then it's a cartel behavior. It has to be at the same line of business. Hub and spoke issue is, say, suppose party A and party B appoint a common distributor, and the distributor acts as a hub to share information of party B with party A and party A with party B respectively, and that helps in forming the cartel. So party A and party B, which is at the horizontal level, are not directly interacting, but
Yeah,
through a hub, distributor C, they are interacting. So that is a hub and spoke issue, which has been specifically, rather not introduced as such, it has been debated in a review committee that it should be brought in. Although again, going by my aggressive interpretation, I may be horribly wrong and subject to correction, that was already there in section 3.1. Be that as it may,
but now it has been formally introduced by way of the amendment bill that we have.
yes. So let us see. So I always say amendment bill unless it becomes a law.
Yeah,
We cannot make it
but
as a
fingers crossed.
tool of interpretation. But having
Yeah,
fingers crossed, it comes.
yeah,
Because why it should come is then you can have the distributor be levied with the same penalty. But
absolutely.
having said that, this is a common issue which everybody keeps on asking as a business person to a lawyer, and it's a normal business. I won't say mistake, but it's a notion. I won't say it's a mistaken notion. It's a good notion.
And sometimes it happens involuntarily, like
Yeah.
with a lot of business entities,
Yes.
that they by chance are a part of a, let's say, an association, which probably has all the competitors in one place, and then whatever gets discussed may be a problem from the CCI's perspective, thinking that okay, this association is facilitating some sort of a cartel,
Correct. So
which the
associate.
companies may not even intending.
Correct. So, like you said, they can be an independent third person or a third enterprise which is not in the same line of business helping it out. So, from a compliance, I do not know whether in-house people have joined this, but there's a common notion that you should not have exclusive agreements, because exclusive agreements are seen with a jaundice type, for a lack of a better word, that it may create an issue. It may not be. It's maybe a violation of section 3.4 read with section 3.1. The flip side to that is, if you do not have exclusive distribution, which essentially means it's a non-exclusive distributor, that means your existing non-exclusive distributor can be a distributor of a competitor also, which can again lead to all these hub and spoke issues which we are talking about, flow of information, etc., which is a bigger risk than having an exclusive agreement. So I always, as an advice to all my clients or contacts or companies, whoever they deal with me personally on an official basis, I always say that in your distributor agreement, you have strong confidentiality clauses linked with termination clauses. So
Yeah,
if you breach confidentiality, you should be allowed to terminate directly without recourse to damages by the distributor. That in essence will, whether you exercise that option is obviously the company's call, but the law should be allowed. So the agreement should allow that. So you cannot have an hub and spoke issue coming in.
absolutely,
Yeah.
absolutely.
So
So
this is my last point. Obviously, then I'll give you another issue, another we have hub and spoke. I think Karan asked this question, so I'll just address this point, and it was my next point also. In UK, uh, there's this new thing which is going around, which is algorithmic collusion, which
Yes.
is nothing but a hub and spoke issue. What is that is somebody, a third party, creates an algorithm, shares that algorithm with all the players in the market, and that person which has created the algorithm monitors the cartel. So whether if there is a deviation or not, etc. So it's case of algorithmic collusion, and you won't believe in UK in 2019, a software supply company, so basically a consulting company, was fined for hub and spoke cartel because they were orchestrating or monitoring the deviation from the cartel. So while the cartel participants obviously has been held to be anti-competitive, was penalized, even the software company, which is nowhere related in the same line of business, was also held to be in violation as such. Rahul has asked,
So
as an
Rahul has
associate,
asked that, yeah, that it has been seen that trade associations acting as catalysts to cartel behavior. Will that trade association be seen as a hub to these entities, although unknowingly? To which I answered that the basis of hub and spoke cartel is that intent is always involved, and the association will be held guilty if there is evidence to prove that it contacted all the entities to cartelize and conduct this whole, orchestrate this whole thing.
and also just to, it's Rahul, right?
Yes.
Yeah, Rahul, just one more point, which it should be an independent. The idea of hub and spoke, although you're right, technically it's not there in the draft of the law. It should be an independent third party. A trade association ultimately is an association of members. So I, as a horizontal level, I'm also part of that member. I'm a member of that trade association. So it's to that extent, while corporate wise, they're a separate entity, but from a competition law angle, which is substance over form, they're not strictly independent because trade associations always are mostly. I've seen some incidents which is not the case, but mostly it's an association of members. So that's why it's, although to an extent you're right, they were hub of discussing all that, but they were not uh, held to be guilty under 3-1, but rather 3-3 only, which is the cartel issue.
Absolutely.
So there goes my uh, trend. Now we can discuss all the big data questions which are there, unless
Definitely.
somebody has a question on hub and spoke.
Absolutely. In fact, I wanted to throw a light on this that we do like especially topics related to big data and hub and spoke. We deal with it extensively in our course that we are taking right now in LawSikho on competition law, where Sir himself is taking classes, especially on the enforcement grounds. And I can see so much interest amongst people right now. So whoever is interested in diving deep into these sessions can always get in touch with me to discuss more as to how you can learn more about it. Having said that, let's go to the questions that have come up with respect to the big data topic. So I think the first question was asked by Manish, which was answered by you. Then Shomritu asked a question saying that should exclusive agreements between tech giants therefore come under severe scrutiny, like advertisement of a OnePlus phone only on Amazon, like through prima facie exclusive agreements are not anti-competitive, but considering the scale of both OnePlus and Amazon, should scrutiny come in? Overall, should exclusivity agreements among cash-rich entities be checked via a threshold?
So while these are being analyzed right now in the e-commerce
It's
case,
a
which
live
is
case that is
it's
going
a
on right
it's a
now.
live case which is going on. So obviously, my view is that it should be investigated and etc. because they are being investigated, and I'm on the side of the traders in this. So this is an issue which is being investigated. So let's see what the CCA comes out with. Obviously, there is a stay which has been granted by Karnataka High Court, which again goes to the point which we did not address in this, was the sectoral issue versus this. But leaving that issue aside, this is an issue which all the authorities across the world, including India, are looking into. Does it lay the red flags? It should. That's why the investigation has started. But let's see what the investigation holds.
Yes, sir. Okay, so now let us see what was the next question that was asked. Okay, so Manish is asking, what is the direction of the CCI to deal with anti-competitive conduct of e-commerce companies within the ambit of law?
So again, there's an investigation. So
Yeah.
what is happening is, just to give a flavor to that investigation, is essentially what the point is that Amazon and Flipkart, respectively, with their with their preferential sellers, some sellers they are given preference, and we had a detailed session on this also, how they're
Yeah.
giving preference. So that was alleged by a group of traders saying that this is anti-competitive and it's a violation of Section 3(4) of the Act. Which the CCI took cognizance of, they are saying that this conduct of platforms not being neutral may cause an issue under competition law. So this was, I think, this was an order dated 10th of January or 9th of January. I don't recall.
Yeah.
I think 3 days before there was a market report which came out by the CCI itself. Maybe that's a good literature that we all should read. It actually laid down what are the issues, and the CCI also gave some recommendations to ensure that the platforms remain neutral. But like I said, apart from the CCA, now the e-commerce policy may come out. There are discussions on that. So let's see what it says. But the broad flavor of everything which is there in the public domain right now, as far as from the regulators and as far as the news bits are concerned, is the platform should remain neutral. And this is an issue which even the EU commissions have also said that a platform which is so heavily funded should remain neutral. So that's an issue which is going on.
Absolutely. Absolutely. So, guys, just be patient with me. I'll take the questions one by one. Okay, so Rahul is asking, so I've come to know that Facebook will be launching an app akin to TikTok, which it didn't do in India until now, since it had no deal with Geo back then. Now, since it will be having the support of Geo's network, it will be launching it now. So my question is, shouldn't the CCI look into future harm on competition due to the data misuse potential of these entities?
See, CCI has already approved the Facebook deal.
Yeah,
Although I have not yet read the order, I don't think the order
it's
has
not
come
out
out.
yet. Yeah, it's
It's
not out.
not out yet. I would assume, like you said, that this all should have been analyzed, because whenever there are two, and this has always been something that a lot of authors have propagated this also. The merger control authorities in India and worldwide are too constrained by the fact that what is the overlap right now as to what is your function, what is the other party's function, and what is the overlap. People do not look into potential overlaps. Like you just mentioned, Geo now can get, so Reliance has already come into Geo Meet, for example, which was not there initially before the deal, for example. So
Yeah,
one should also look at potential overlaps. So let us wait for the actual CCA order to be out. But from a purely behavioral, so let's flip the example and see whether they can be held to be in violation of Section 4. Facebook is definitely dominant in social media. There's
yeah,
no question on that. I don't think there's any other alternative also. They have been held to be dominant in the sphere of digital advertising. Let's see whether in India also that's the case. So definitely a case can be made out, if not anything for leveraging, for example, whether they're using their power to do this. So case definitely can be made out. So let's see whether they will be. Google is right now being investigated. So worldwide. So let's give the CCI its time, but CCI should act fast. Like at least come out with an advocacy initiative to understand their practices in India.
absolutely. Also, what usually happens in merger control in these kind of scenarios is that when the CCI is approving these kind of transactions, and especially these kind of sensitive transactions, the CCI will always kind of give a recommendation in the form of some sort of a, let's say, commitment that it will take from the parties. That okay, you're entering into this deal, but please ensure that you don't enter into these kind of arrangement at least for a couple of years, and we will be monitoring your actions. Also, I read somewhere that Geo had made it very clear that their present deal does not entail any data sharing provisions, which it
Yes.
had where it had come out in the newspaper, which was hard for me to believe. But with respect to your question, that is something the CCI will certainly be monitoring while approving the transaction. So after the approval, it's not like the CCI will turn a blind eye to this entire transaction. There's even more responsibility and, let's say, scrutiny on Facebook and Geo after this.
Yes.
Okay. So right now, Let me see if I've missed out any questions in between. Okay, so Anuja is asking, let me get to Anuja's question. One second. Anuja, are you there? I think I can't find your question over here. If I can just request you to unmute yourself and ask your question. Uh, One second. I think, sir, are you able to locate your question?
Can we ask Anuja to type the question
Okay,
again?
yeah, I found it. I found
Yeah.
it. So Anuja was asking that now after the Facebook investments into Jio, Amazon, and Google have planned or announced investments in Vodafone and Airtel, this essentially does lead to big tech entering the telecom industry. What impact do you see from a competition law perspective? Will this lead to throttling of privacy? Should competition law be involved in these discussions? If yes, how?
See, privacy is something obviously we urgently require a data protection law. So, is
Yeah,
competition law adopt in under a data privacy violation can be I sincerely believe
yeah,
it can be a competition law violation because at the end of the day, consumers are getting affected. But the extent or the harm which has been done to the consumers because of data privacy issues or leakage of personal data thereof has to be done by an independent regulator. So it can be an overlap, it can be a mix of both. Like I said, competition law authorities must be regulating market conduct, and privacy data breach is definitely one of them. Now, with this whole investments coming in of Amazon investing in Airtel, so we are coming to a situation wherein a big tech. So suppose, for example, and just this is hypothetical, Amazon invests in Airtel, and then slowly and steadily in Airtel phones, for example, there is a something will happen that you cannot, for example, log into Flipkart
yeah,
or log into any other uh, shopping websites, for example. Just a thought. It may or may not happen. I do not know. Or maybe the data charges, something will be different. Similarly, is the case with the Facebook Geo deal, which also happened. So these are the kind of issues which maybe not be a plan from day one, but then that's where a regulator with an expert can think that okay, fine, it may happen 3 years from now. It's very difficult to plan always. So you may not give a remedy now because the plan doesn't exist, but keep a monitoring. That's why periodically you have in UK and EU, for example, just as an anecdote, EU had their market definition. They have their market definition notice. How do you define the relevant market? They are now re-evaluating it in 2020. You always, as a regulator, because you have advocacy functions also, you need to evaluate the conduct of people, engage with those enterprises, send them questionnaires so that they give their responses. You have the power under Section 49 of the Act. Might as well use it.
yes, sir. So, Rahul, was your question resolved, or do you have any counter question to that? You can also unmute yourself and ask your question because I can see there are a lot of queries on the chat box. But in case if Rahul, you're there, uh, okay, I don't know if he can. Yes, Rahul, I've unmuted you. Okay, so Rahul's question has been settled. Okay, so I understand, Rahul, that we didn't delve into overlaps, sectoral overlap, because I conducted a very full-fledged session on it with Avinash Amarnath. I can also share the link with you. But if you have any particular question with respect to the CCR versus Bharti Airtel case, we can definitely discuss it here. So Rahul, you can unmute yourself and ask. Like he basically wanted to ask that what you were going to discuss with respect to sectoral overlap.
Yes, so to an extent, Rahul is right that the
Yeah.
law is settled. But the law is settled how?
Actually settled in the sense that his question was settled.
No, no, no. So if you see, may I ask what were you going to discuss with secretarial overlap with the
Okay,
VCCI
okay,
since the issue was settled by Supreme Court?
fine.
So what the issue actually, what the case actually said was that since there are certain issues which require the technical expertise of a regulator, let them first decide and let the CCI come in. So CCI's jurisdiction is not ousted. Now, taking that example forward, uh, what are the kind of issues which require technical input as required? So in this case, it was saying that points of interconnection. How do you define technical inputs? So for example, in the live case that we are doing, again, so that's why I said Karnataka High Court. The issue is, without delving of what I think, the issue in that is of the e-commerce policy. The court has granted a stay reading Bharti Airtel judgment, and the court has said that since the enforcement directorate, which is an authority under Foreign Exchange Management Act, is looking into the same issues, let the ED come out with a report and then let the CCI come in. So the interpretation of this judgment may be required further elaboration in some of the subsequent cases. So this is what I wanted to discuss. Obviously, then there's an issue which is going around in Delhi High Court also in the Ericsson and the Monsanto case, wherein the Delhi High Court, the single judge bench, has said their remedies is different, it doesn't overlap, but the parties have gone into a division bench saying that the Patents Act or the Copyright Act or whatever the IPR statute is the correct forum to deal with these disputes. So we'll see how it goes, how it pans out. Bharti Airtel definitely touched on one thing, but I sincerely do not think that they have settled all the issues on regulatory turf for.
Absolutely, absolutely. So, guys, any question that I have missed or any other query that you guys have? Like, I understand from, at least with respect to the data, the big data issues, a lot of people have their concerns thinking that, okay, regulators outside India are taking such proactive measures. Isn't India supposed to do the same? Won't India also, isn't the CCI also equally responsible to be that proactive? To that, I feel at least in the last 3 years, CCI has become very, very proactive. And this, like CCI itself is conducting its market study and has taken up a number of matters. I think the most premier matters that are going on right now is with respect to tech companies. So it's not like CCI is turning a blind eye. In my opinion, CCI is definitely developing the legislation slowly but steadily.
Yes, the they are, like I said previously by saying that they are, but I think they have to be more. My only uh, I don't think I should use the word criticisms, but one of my only requests to the CCI is that we should not be constrained by the statutes. It's a very vastly written statute. You should use your statute to curb the mischief. So, like the other authorities have done, maybe the right way to approach, rather than, obviously there is a case which is going on, so investigate that case, but also have a market survey is something. So that will give a holistic perspective. The UK report is 430 pages. After I read 10 pages, I went back as to what did I read in those 10 pages. So it's extremely, every word gives you an information. So there's that much conduct. So I'm sure UK as a market is half the size of India. So I'm sure there will be more practices in India with them. So in UK, I'll just go through the figure once, which I had noted down. They said that the digital advertising is just 1 second. It's 14 billion pounds. Here you're talking about 2000 billion. So
Absolutely. Manish has asked a question which I feel is of personal interest to Sir. That there was a case in 2017 in EU wherein ECJ said that Uber is not just platform to provide digital services but transportation services. What is your view on that?
so Manish, again, so this is a live case that I'm doing against Uber. So we are representing Meru and Fast Track in the dispute right now before various forums. So on this specific issue, there are conflicting judgments, to be honest with you, in US. But in India, there's a Karnataka High Court judgment, a single judge bench in Karnataka High Court, which has clearly said, and I'll quote because I can quote a judgment, it's not my view. It says the Uber's argument that they are a mere digital platform is nothing but more than a hypnotic illusion. They are a transportation company. This is a single judge view of Karnataka High Court. Obviously, Uber went in appeal, and it got they are still debating on that. There is an EU judgment to that effect. Here, even the CCI has said that they are a transportation company, not merely a digital platform. They said in reference to Ola. I'm sure that will apply to Uber also. So that is the case. On Mohammed's question, what is the case name in the judgment? It's, I think, Satish and others versus Uber Transportation.
Yes. Okay, absolutely. So, thank you so much, sir, for this extremely enriching session
Yeah.
that you took with respect to the emerging trends that we are going to be seeing. I think we have a final question from Karan. That, sir, do you think there will be a rise in mergers and acquisition after a year or so due to COVID impact? If yes, will the CCI change its approach of rubber stamping every transaction, which it has been doing so since its inception? Karan, you've actually like asked a extremely sensitive question in a very blunt manner. And to be very honest, I would not completely agree with it, having worked in the merger control sector as well, that CCI does not act as a rubber stamp to every transaction. There have been a lot of transactions that CCI has even taken almost a year to legislate upon. But sir, definitely I would like to have your views on this as well.
Yeah. So to let's divide the questions. Do you think there will be a rise? I think there will be a rise because the valuations of the company will go down. Companies which are cash rich after this, I think they will wait for this financial year because cash is king. This is my opinion. I'm not a corporate lawyer, but
Also, like, I would just like to add one thing, that there's a new amendment which says that now deal value thresholds will also become a criteria,
yeah.
which was not there before. Because
So
of that, a lot of like a lot of value-based transactions used to escape.
yeah,
Now, if
that's
you
what.
bring this in,
Yeah,
transactions will also come in.
that's what some of the countries like Austria and Canada have done it. So they want let's see because that becomes, like I said, how do you determine a value to a deal? But that is a separate issue.
Yeah.
Do you think there will be a rise in M&A? I think yes, because the valuations will go down. People who have cash will buy. On the issue of change in approach, like I think it's slightly unfair criticism, which has been there. Can CCI do a better job as far as so financial transactions? They do a good job on strategic acquisitions. Also, they have given remedies, etc. Like Manish is saying, PVR DT Cinema was a good example, I
Lots
guess.
of examples like the Sun ran back, see the
Sun
recent
Random,
one, L&T and
yeah,
Schneider,
yeah. But I
and
think Karan is slightly jaundiced by the Facebook Reliance Jio approval.
I
But
can.
Karan, let's wait for the order because the order
And
is
we
not out
actually
yet.
discussed it. Yeah, we discussed it at length in our course that, like in our classes, that why the Facebook Geo deal is not as problematic as people are perceiving it to be. Like on a technical ground, why the CCI may not be completely wrong in approving it. So
Yeah,
we
so
go in depth in our
if,
classes.
let the order come out. So
Yeah,
obviously,
absolutely.
can so then we can actually have a debate as to whether they could have done more
Yeah,
than that in terms of monitoring because like merger control is a forward looking exercise, but you can't forward in speculation. It has to be something which exists today. But so let's see the order. So I will not pass a judgment one way or the other. But generally, my view is big tech companies, like all authorities, CCI should act. Whether quad this deal, let's wait for the order. Because now Intel has also invested.
yeah,
So that is another thing.
absolutely. So, guys, if you have any other question, we can definitely please reach out to me with those questions. I will share it with Sir, and I'll definitely get you guys the answer. I apologize, we are actually running a bit short on time because we will probably have another session starting or something. But thank you so much, sir. This was wonderful. I really didn't expect that people will be that proactive at this hour, like during dinner time. But
Not a-
thank you,
I
every.
hope I hope everybody enjoyed the session. I really enjoyed delivering it. So
Absolutely. So, in fact, guys, we will be having these regular sessions on such contemporary topics, especially if you guys are, interested in pursuing a future in this particular law. And like I said, if you have any queries with respect to what all we deal with in our course, because Sir himself takes a lot of classes, please do get in touch with me. And I think there was a query from Manish or Rahul, I don't know, with respect to the process that CCI follows
for
for entertaining informations. I think that was a query that Manish had
so,
stated.
so is he asking for during these time or generally?
Yeah, I can't seem to find the question, but yeah, like in short, Manish, the general regulations of 2009 give you the entire process as to how you can file an information before the CCI. You can either a person can file it or the CCI can take a suo motu cognizance of it. Let me see if Manish has asked the question again. Okay, sorry. I think it must be someone else. But great, guys. So if any one of you have any other questions, please let me know. Thank you so much, sir. This was a fantastic session that we had, and we hope to see you in future sessions as well.
Sure. Thank
Uh,
you. Thank you, everyone.
Thank you, everyone. Good night. Thank you so
Good night.
much for attending.
Thank you. See you.